Hi, good morning, everyone. Can you all hear me and see the presentation?
Yes, we can hear you.
Okay, great. Hi, so my name is Stephanie Breen, and I am the school policy attorney at SALI. And so this portion of our presentation is to review the laws and regulations surrounding Title IX and school misconduct cases. So we are going to discuss when Title IX regulations apply to a case that you are considering taking on. And this is important because you will only get reimbursed through MHEC if Title IX applies. Then we are going to discuss if the Title IX regulations do apply, what the formal investigation process looks like under the applicable laws. So the applicable laws are Title IX, Cleary, and the Maryland Education Article, Section 11601. Title IX is a federal civil rights law. It applies to K through 12 students and to higher education. The MHEC reimbursement program does not reimburse for work with K through 12 students, but that is work that you can take on under Title IX. The Cleary Act is also a federal law. And it only applies to higher education as well. We're going to discuss Cleary because it puts some additional requirements on schools, and I'll explain what those requirements are later in the training. And then Maryland Education Article is, of course, a Maryland state law, and it requires that colleges and universities adopt written policies on sexual assault. The law also imposes a few additional requirements on Maryland colleges and universities that we'll discuss later in the training. So the statute itself of Title IX says that schools are not allowed to discriminate on the basis of sex in the context of an educational program or activity, and that Title IX applies to any school that receives federal financial assistance. Unless that school is exercising a religious waiver. So schools that have a religious mission may be able to apply for a waiver that states that Title IX should not apply because it would violate their religious beliefs. But otherwise, Title IX will apply to most colleges and universities, whether private or public, because most colleges and universities receive some form of federal financial assistance. So, for example, they could accept students who receive federal financial aid, or maybe they have a land grant. Title IX does not apply to most private K through 12 schools, though, because they generally do not take any federal funding. Okay, so where are we now and where are we going? So the Department of Education under the Trump administration issued new Title IX regulations following a formal notice and comments process. So the regulations were proposed back in 2018. They were finalized in May of 2020, and then they went into effect on August 14th of 2020. These regulations were a really big deal because they completely overhauled how schools had to comply with Title IX. That schools had to completely rewrite their policies, essentially, to be in compliance. And the regulations were generally viewed as being favorable to respondents. So the idea behind the new regulations was to strengthen the rights of the accused of respondents in these hearings. However, a lot of organizations that represent survivors tend to see these regulations as not being very survivor friendly and not being good for complainants. Some of the changes that the Trump administration made included narrowing the definition of sexual harassment, which meant that less types of conduct were able to meet that definition. They also added new due process measures for students accused of misconduct, and they added more stringent procedures for investigating cases of sexual harassment. So, for example, the new regulations require live hearings with an opportunity for cross-examination. Now, the Biden administration has stated that they're committed to overturning many of the Trump era changes to the regulations. And so they've issued some proposed rules, and they are anticipated to make a number of changes. So what we anticipate from the new regulations is that they will find more of a balance between the rights of survivors and the rights of the accused, that they will expand protections for LGBTQIA+ students, and that they'll make it easier for victims to report sexual harassment by changing the definition of what sexual harassment is to a lower standard that more conduct will qualify. The Biden administration's final rules were originally supposed to be issued in May of this year, but they were delayed until October. And then that deadline has, of course, come and passed. And the expectation now is that the final rules will not be released until the end of December at the very earliest, with next year being more likely. So essentially, everything that I will be talking about today is subject to change. But unfortunately, we don't know for sure when to expect those new regulations to be issued. So the Trump era regulations will continue to be the law of the land and for a little while longer. So does Title IX apply? When you start working on sexual misconduct cases, one of the first things that you should evaluate is whether Title IX applies. You're only going to be reimbursed by MHEC if the case is an actual Title IX case. So it's important to recognize that in this space, many people will use the phrase Title IX to refer to any school sexual misconduct case, when really the conduct at issue doesn't actually fall within Title IX. So schools actually often operate with two separate policies, one Title IX policy and then an other sexual misconduct policy. So there are a lot of other kinds of sexual assault, sexual harassment, and other student misconduct cases that may appear to be very similar to a Title IX case, but to which Title IX actually will not apply. So there are a number of requirements that a case must meet in order for Title IX to apply. First, the complainant must be participating or seeking to participate in the school's educational program or activity. Next, the conduct at issue must meet the definition of sexual harassment, and then the conduct must meet the Title IX jurisdictional requirements. Sexual harassment. So as I stated, the 2020 regulations changed the definition of what sexual harassment is under Title IX, narrowing it from its prior definition. Previously, sexual harassment was generally understood to be unwelcome conduct of a sexual nature that affected someone's ability to access their education. The 2020 definitions narrowed that definition of sexual harassment to be one of these three options here on the screen. So first, sexual harassment for Title IX purposes can be any individual act that is a sex offense as defined by the Cleary Act. And the Cleary Act defines sex offense as either sexual assault, which includes rape, fondling, incest, or statutory rape, domestic violence, stalking, or dating violence. Sexual harassment can also be an explicit quid pro quo from an employee of the school. This is where an employee may condition some kind of a benefit on the receipt of a sexual favor. So for example, a professor might condition a high grade for the semester on a sexual favor from a student. Quid pro quos only count as sexual harassment under Title IX if they are perpetrated by an employee of the school. So a student in a position of power over another student would not qualify. And finally, any non-physical assault that does not fall under the Cleary Act can constitute sexual harassment, but it has to be conduct that a reasonable person would deem so severe, pervasive, and objectively offensive, that it effectively denies a person equal access to their education. So for anyone who does employment discrimination or Title VII work, it's important to note here that the standard for Title IX is higher. It's not severe, pervasive, or objectively offensive like under Title VII, but it's severe, pervasive, and objectively offensive. So the behaviors have to meet each of those three criteria. So a lot of behaviors that may have qualified under Title VII, of course, will not qualify under Title IX. So to provide some examples, a series of microaggressions that occurs over a long period of time might be considered pervasive, but not sufficiently severe. And then on the other hand, a single lewd and shocking comment may be sufficiently severe, but not pervasive. And then the requirement that the conduct deny a person equal access to education, that does not mean that the student has to have completely dropped out or missed a class. It's enough that a student is just having trouble maybe getting to one of their classes or having trouble participating in a single activity. For example, maybe their GPA is suffering. So this element is interpreted more broadly than a student just not being able to go to school anymore. Jurisdiction. So under the current regulations, sexual misconduct must have occurred within the United States in order to fall under Title IX. So even if the conduct occurred during a school-sponsored trip or in a study abroad dorm room that's owned by the school, the conduct still will not be covered by Title IX. Additionally, the conduct must have occurred under an education program or activity. This means that the conduct has to have occurred in a location or during an event controlled or owned by the school. This includes buildings that are owned or controlled by an officially recognized student organization. So for example, an assault that occurs off campus at a house that's owned by a fraternity, that would fall under Title IX. So most schools will likely say that any misconduct that occurred off campus and not in a campus-owned building does not fall under Title IX. However, this is something that you can push back against a little because sexual misconduct occurring off campus is a fact-specific inquiry. So you'll have to evaluate how much control the school had over the respondent and the context in which the harassment occurred. Ultimately, though, the jurisdictional requirement will remove the majority of sexual misconduct cases from Title IX because most assaults at universities and colleges do occur off campus, in off-campus housing, at parties, at bars, and other similar places, but not actually on school grounds. So we know a lot of harassment occurs online in the online space. And unfortunately, the 2020 regulations do not expressly address cyber harassment. The preamble, though, to the regulations does clarify that Title IX may have jurisdiction over conduct occurring in online spaces if the fact-specific inquiry shows that a school has control over the respondent and over the context in which the harassment occurs. The preamble gives the example of a student sitting in class and using a personal device to harass a fellow student. The school has control over that context, the classroom, as well as over the student because the student is at school. So Title IX would apply there. However, if a student is located in their off-campus housing and they're using their personal laptop without using any school account, like a school Zoom account, then that conduct may not qualify. Because this is a fact-specific inquiry, you can definitely argue at the margins, but a lot of harassing conduct may not meet the jurisdictional requirements under the current regulations. And I'm realizing that I can't see if there are any questions. So if I miss something, I will definitely respond to them at the end of the presentation. So please be sure to take note of those. Okay, so actual knowledge. Colleges and universities are only required to respond to sexual harassment when they have received actual knowledge of it. Once they know about the harassment, they are required to respond to it. For higher education, actual knowledge only exists when reports of sexual harassment are made directly to the Title IX coordinator. Under prior regulations, it was that reports to any responsible employee of the school were sufficient to create actual knowledge. So students could disclose harassment to a professor, a coach, an administrator, for example. Those were all sufficient. However, under the current regulations, actual knowledge is much more limited for higher education. So the prior definition of actual knowledge actually is still in place for K through 12 schools, but for our purposes for higher education, students have to report to the Title IX coordinator. But many schools have voluntarily chosen to retain the responsible employee standard of the past in their sexual misconduct policies. So students should be aware in those situations that if they disclose harassment to their favorite professor or to a coach, it is possible that they will need to inform the Title IX office, and then the Title IX office may reach out to them, and it could lead to an investigation. So it's just going to depend school by school what they have in their policy. Once a school has actual knowledge of sexual harassment, it has the option to remove a respondent prior to conducting any investigation or adjudication, but this is only if there's an emergency situation. And an emergency situation would be any immediate threat to the physical health and safety of a student. The assessment of this threat must be individualized, so schools cannot have blanket removal policies. For example, schools are not permitted to have a blanket policy that says that all assaults with a weapon are considered to be an immediate threat to the physical health and safety of students. Each specific incident must be subject to an individualized assessment of if there's a threat. If a school does conduct such an assessment and determines that a respondent is a threat, then the school must provide the respondent with notice and an opportunity to challenge that determination immediately following the removal. Schools should also be thoroughly documenting the reasons why they have found a respondent to be a threat to health and safety, so that as an advisor, you can review that. This emergency removal provision does not apply to employees of the school. Any employee who is accused of sexual harassment may be placed on administrative leave during the investigation or the formal grievance procedure. Formal complaints. So schools will only investigate claims of sexual harassment once they receive a formal complaint that is in writing and signed. The formal complaint can be signed either by the complainant or by the Title IX coordinator. And what this means is that a school could conduct an investigation without the consent of the complainant. However, this doesn't happen very often in practice. Usually schools will only initiate an investigation without the consent of a complainant if there is a severe danger to the community or if the school is very worried about the perpetrator. However, Title IX cannot be used to investigate a formal complaint if the complainant is not actively participating in or seeking to participate in the educational program or activity at the time that the complaint is filed. So a student who is assaulted while attending college, but then who drops out with no intention to return, cannot file a Title IX complaint. Another example would be a student who's visiting a friend at another college. If they are assaulted at that college, they will not be able to file a Title IX complaint at that school. There are certain situations where schools are required to dismiss sexual harassment complaints under Title IX, and then other situations where schools are permitted but not required to dismiss complaints. Schools must dismiss sexual harassment complaints if they do not meet the definition of sexual harassment, if the conduct occurred outside of an education program or activity, or if the conduct did not occur in the United States. Schools may dismiss sexual harassment complaints if the complainant requests it, if the respondent withdraws from the school or quits the school, or if circumstances prevent the school from being able to gather sufficient evidence. And the inability to gather sufficient evidence does not mean that the complainant was unable to meet their burden of proof, but rather it means that it refers to circumstances such as key witnesses being unavailable to testify, and the school just cannot move forward. It's important to be aware that dismissal of a complaint under Title IX does not necessarily mean that the school is not going to investigate the sexual harassment under their other sexual misconduct policy. Some students in the past have gotten confused when they were told that their complaint was dismissed under Title IX, but then they were still told to come in for an interview and that there would still be a formal investigation. The dismissal of a complaint under Title IX doesn't necessarily mean that the complaint is dismissed in its entirety, because there's still that other sexual misconduct policy at schools. In Sally's experience, colleges and universities in Maryland are voluntarily choosing to still investigate sexual misconduct that doesn't fall under Title IX. At some schools, the process will look exactly the same as the Title IX process. So for example, the University of Maryland College Park has identical processes for its Title IX and non-Title IX complaints. But then at other schools, such as Johns Hopkins University in Baltimore, the non-Title IX process is very different from the current Title IX process, and it actually reflects how the Title IX process used to be prior to the 2020 regulations. It was a shorter process, and it involved a lot fewer reports. So whether or not Title IX applies may or may not impact what the process will look like for complaints of sexual harassment. The next question is whether Cleary applies. So the Cleary Act is a consumer protection law, and it applies only to higher education. The Cleary Act requires that institutions compile and report crime statistics in order to let the community know how safe the campus is. So Cleary reports are not only for sex-based crimes, but they're actually for other crimes as well, like burglary or arson. Schools are required to publish a report stating how many crimes have occurred within what's called the Cleary geography. And that means any crimes that have physically occurred on the school's campus or in their buildings. The origins of this law are that it was lobbied for by the parents of Jean Cleary, who was unfortunately raped and murdered on her college campus. After the attack, her parents learned that there had actually been a series of violent incidents on campus prior to that attack. And they thought that maybe if they had known about the violence on campus beforehand, that it wouldn't have happened, or that something could have been different. So the purpose of Cleary is to keep students informed so that they can make informed decisions about their safety. Cleary has a set of amendments that we call the VAWA amendments. These amendments were added in 2013 with the passage of the Violence Against Women Reauthorization Act. And the VAWA provisions state that survivors of sexual assault, domestic violence, dating violence, and stalking have some additional rights. So unlike the crime reporting provisions of Cleary, which only require universities to report on crimes that occur on their campus, the VAWA provisions are not geographically bound. So a survivor's rights under Cleary will apply regardless of where the assault occurred. And although we're focusing today on Title IX, it's important to be aware of Cleary generally as an advocate because it can do a lot of work for survivors when Title IX doesn't apply. The VAWA provisions impose requirements on what school misconduct policies must look like when they are applied to a VAWA crime. So even when misconduct does not fall under Title IX, if it constitutes a VAWA crime, the school's misconduct policy must comply with the VAWA provisions of Cleary. And we'll discuss as we move through the presentation what some of those requirements are. So enforcement. Unlike Title IX, which does create a private right of action, Cleary does not. So students cannot sue someone or sue a school under Cleary. However, they do have the ability to file a complaint with the Department of Education. The penalty for Cleary violations is fines against institutions, which can go up to $59,000 per infraction. And this applies both to the crime reporting provisions as well as to the VAWA amendments. So threatening a school with a Cleary Act complaint can be a very effective tool to bring a school into compliance. So if you've determined that Title IX does apply and Cleary may or may not apply, what is the next step? So the next step is to look into supportive measures for your client. A complainant who reports to their school does not have to go through a formal investigation or have a hearing and adjudication. What they can do if they want is report just to receive supportive measures. Schools are required to talk to complainants about supportive measures under both Title IX and under the Maryland Education article. Under Title IX, supportive measures are no-cost measures designed to restore equal access to education or to restore campus safety. So the Title IX coordinator must reach out to the complainant and offer them supportive measures upon the school's receipt of actual knowledge. Supportive measures have to be non-punitive and they cannot be overly burdensome to the respondent until there has been an actual adjudication and a final finding against the respondent. This doesn't mean that there cannot be any effect at all on the respondent, though. So supportive measures are allowed to be burdensome, somewhat burdensome. They just can't be overly burdensome. And this is going to be a fact-specific inquiry. Title IX doesn't require that any specific supportive measures be offered, but it does give examples of what can be offered, such as academic accommodations, no contact orders, counseling referrals, and other similar accommodations. Depending on the facts of the case, schools may be allowed to remove a respondent from participation in sports, so long as it is not punitive. The Maryland Education article imposes more specific measures than just requiring a school to have a conversation with a complainant about supportive measures. So if the conduct committed by a respondent constitutes a crime or could constitute a crime, Maryland law requires that schools tell the victim that they have the right to file criminal charges and that the school assist the complainant in filing those charges. Maryland also requires schools to designate the nearest safe hospital and to transport complainants to that safe hospital for medical treatment and for a medical exam. And a safe hospital is a hospital that conducts sexual assault forensic exams. Maryland schools require as well that schools either offer on-campus counseling, or if the school doesn't have on-campus resources for that, that schools refer complainants to a local rape crisis center. And finally, if it's feasible and if the complainant requests it, schools have to help complainants transfer their classes or transfer their housing. Neither Title IX nor Maryland law requires that respondents receive supportive measures in the same way that complainants must receive them. However, there's also nothing in either law that states that schools cannot offer respondent supportive measures, and most actually do. So if you work with respondents, it is very reasonable to ask the school for supportive measures to help make sure they can manage their classwork while they navigate the Title IX process. And these measures can help generally just help students to stay in school throughout this process and to feel safer while they're in school. So after receiving supportive measures, a complainant may decide that they want to go forward with the formal investigation process. The investigation process can also be initiated by the school without any request by the complainant. So for example, a school may decide to do an investigation based on concerning reports from a complainant's peers, their professors, or other concerned members in the campus community. However, this is very rare. So in the majority of cases, if a complainant expresses that they do not want to go forward with an investigation and that they want to keep, maybe they want to keep the respondent's identity anonymous or keep the complaint anonymous, schools will allow that. However, it can happen where schools are concerned enough by the reports that they will choose to go forward with an investigation anyways. So the VAWA amendments to Cleary require that any formal process or meeting that's used to investigate and adjudicate a sexual misconduct claim be prompt, fair, and impartial at every stage. Cleary also states that the process must be transparent to both parties. Part of what this means is that schools must follow their own stated policies. So schools can put things in their policies that are not required by any law to be included, but once that item is included, schools must abide by it. And this is because both students in the process have the right to know what to expect throughout every stage and what their rights are at the school. So Title IX is very prescriptive, and there are a lot of rules that all schools should be following. But there is flexibility there for schools to include their own policies and their own procedures. As an advisor, when you get a new case, the very first thing that you should do is go to the school's website and read through the school's policy multiple times, maybe 3-4 times, because it's very important to be familiar with the school's policy in order to be an effective advocate. The sexual misconduct process is required by Title IX, Cleary, and Maryland law to be prompt. Title IX uses the language prompt, and then Maryland law says reasonably prompt. But the 2020 regulations to Title IX do not actually define what promptness means. So in the past, the regulations stated that investigations should be conducted within 60 days, but that 60-day limitation is no longer required. So what is considered prompt is really left up to the schools. Cleary says that schools should put in an expected timeline if there's going to be any delays. And then both Title IX and Cleary state that the process can be delayed for good cause. If that happens, Cleary requires that schools notify parties in writing for the reason for the delay. Under the 2020 regulations, unfortunately, cases are taking much longer than they used to under the old regulations, sometimes as much as 2 to 3 times as long. One of our attorneys at SALI had a case that did not resolve for 10 months from complaint to hearing. And if there had been an appeal, it would have, of course, taken even longer. I'm not sure that anyone at SALI has had a Title IX case that was resolved in under 6 months over the last year or so. And not only are cases taking a long time, but it's causing schools to violate Cleary. Part of that reason is they're not giving the written notification for the reason for the delays. And it might be because in the past, Cleary was completely subsumed by Title IX. And Title IX actually covered a lot more of what Cleary covers now. So schools might not even realize that they are violating Cleary. And Title IX provides some examples of what may constitute good cause for temporary delays. So it includes if either party is absent, if there is any law enforcement activity that's happening at the same time, or if there's a need for language assistance. If I was giving this training to school officials, what I would say is that the last two examples are not good cause for delay, because Title IX does not overlap with the criminal justice system, and it is possible to conduct both types of activity at the same time. Law enforcement activity, and especially criminal cases, can take a very long time, whereas Title IX cases are supposed to be resolved promptly because the condition of being a student is temporary. So when these cases are taking as long as 10 months, it means that they are going on for almost a quarter of an undergraduate student's time in college. And they need to be resolved more quickly than what it takes for a criminal case to make its way through the criminal justice system. And then schools also should already have a plan in place for language assistance. So again, these things may constitute good cause, but they're not definitively good cause. And it's, again, going to be a fact-specific and situation-specific determination. When Cleary says prompt, it says that the reasons for the delay have to be put in writing. And unfortunately, in our experience, schools are violating this frequently. And it's largely due to the fact that all of the additional requirements under the 2020 regulations just make the process take a pretty long time. So under Title IX, schools are required to provide both parties with notice of the allegations. The respondent must receive notice of the identity of their accuser and the date, time, and location where the alleged conduct took place. Both parties are required to be notified of their right to an advisor of their choice, and both parties are to be told that there is a prohibition against making false statements. Both parties must also be told that there is a presumption that the respondent is not responsible for the conduct alleged until a final determination has been made. And this is reminiscent of the idea of being innocent until proven guilty in criminal law, although this is not supposed to be like a legal process or a criminal process. So schools will love to tell you that this is not a legal process, that this is not a court of law. However, the 2020 regulations do impose a lot more due process from the criminal justice system than what was previously imposed. So Maryland law requires more in terms of notice than Title IX does. Under the education article provision, both parties are entitled to written notice of the alleged violation, including the range of potential sanctions. Cleary also requires schools to provide a range of potential sanctions. And this can include things ranging from the respondent writing an essay about what they did or giving an apology to suspension or expulsion from school. It's important for advocates who are representing complainants and respondents to understand that there's just a huge range of possible sanctions. So schools are not limited to deciding that a respondent will be expelled or not be expelled. There's a whole range of options in between. Both parties also have to be notified not only of the right to have an advocate of their choice, but that they have the right to a trained advocate or to an attorney, such as those on MHEC's list. Under Maryland law, parties also have the right to have a support person. So Maryland law says that both parties have the right to have no more than 2 people with them at anything where their physical or virtual presence is required. This means that at any meeting or interview and at the final hearing, each party can have their advisor as well as a support person. And the support person can be a family member, a friend. They can also be someone else who works in your office with you as an advocate. So you could have someone be there taking notes, or it could be someone else. Federal law doesn't say anything about support persons. The only thing it does say is that any restrictions placed on a school must be placed equally on both parties. But under Maryland law, it is specified that there can be no more than 2 people at each meeting. So the reason we're here today is because of the Maryland law. And it says not only do parties have the right to have an attorney or advocate present, but that the parties have the right to have an attorney or advocate free of charge. And that's where MHEC comes in. Both Cleary and Title IX state that the advisor the student chooses must be their advisor of choice. Schools cannot put any limitations on a student's choice of advisor. So the advisor could be an attorney, or it could be a parent, a teammate, a sorority sister. An advisor can be someone who's not qualified at all to give advice about these kinds of proceedings. Advisors can even be witnesses in the actual case. So there's just no limitations there. But schools can put restrictions on support people if they want. Those restrictions just have to apply equally to both parties. So schools can, and they often do, state that support people cannot be witnesses. So there is an informal resolution or mediation mechanism that is available under the law that is important to understand. The Title IX regulations state that schools may offer mediation except in cases between a student and an employee. So mediation cannot be offered in cases where the respondent is a professor or someone else who works for the school. Otherwise, mediation is permitted under Title IX so long as both parties consent and they consent in writing. Mediation can never be required, and either party may withdraw from the mediation process at any time. Maryland law imposes limits on mediation. So Maryland law states that mediation should be offered except in cases dealing with sexual assault and sexual coercion. If mediation is offered under Maryland law, it can only be offered after a complainant has requested it. All parties must agree to engage in mediation, and either party may withdraw at any time. Additionally, Maryland law requires that the school have staff who are specifically trained to conduct mediations. So schools in Maryland have taken this part of the law to mean that they are not allowed to offer any sort of informal resolution at all. Informal resolution is where the parties would work out a private agreement, which would spell out the terms moving forward. So for example, the parties could agree that one party will drop out or transfer, or maybe they will set terms limiting the parties' interactions on campus. And this can lead to really good results for both parties when they're able to work their issues out this way. And although many schools may think that they're not allowed to permit informal resolution, that's actually not true. So schools are allowed to permit informal resolution. They are just not permitted to facilitate that informal resolution process themselves. And the reason for this is because sexual assault and sexual harassment are conduct that is characterized by a power imbalance. So this type of conduct is all about power and control, and you can't really mediate between parties when there's a power imbalance. But when both sides have an attorney and neither side wants to go through the formal process, the best practice is for schools to permit them to engage in informal resolution, because there's no longer a power imbalance when both sides are represented by an attorney or by an advocate. So as an advocate, you should push back against schools who think that they're not allowed to permit you to engage in informal resolution. So during a Title IX investigation, schools are generally not allowed to restrict parties' ability to build their own case. Both parties should be allowed to investigate, to gather their own evidence, and to talk to potential witnesses. This is very different from what the regulation said prior to 2020. So before, schools would actually often issue gag orders saying that parties were not allowed to talk about the case and that they could not investigate or talk to witnesses because it was the school's job to conduct the investigation. And sometimes advocates would even get into trouble for trying to talk to a witness on their client's behalf. But now under the 2020 regulations, that has gone away. And while schools do conduct their own investigation, parties are permitted to engage in the investigation process as well. The only limitation is that parties may not access, consider, disclose, or otherwise use a party's medical or mental health records without the subject's voluntary and written consent. So the investigation will include interviews of both parties and interviews of any witnesses. And both sides are permitted to provide witnesses for the school to consider and to interview. And usually both sides will be permitted to review the transcripts of the interviews and to correct them if there's anything that they see that's a mistake. After the investigation process has concluded and all of the evidence has been gathered, the school will compile an initial investigative report. This report will summarize all of the evidence that has anything to do with the case. So at this stage of the process, it doesn't matter if the evidence is relevant, it just has to be related. So this is very broad. It also doesn't matter if the school intends to rely on that evidence in making its decision. Other than mental health and medical information, there's essentially nothing that can be taken out of the first round of reports. All of the evidence that's related in any way to the case has to be included in that initial investigative report. Once it's compiled, the school must make the initial report available to both parties and to the parties' advisors. So the school is actually required to send the report directly to parties' advisors. And this is the only time in the process that schools are actually required to communicate directly with the parties' advisors as well as with each party. So most of the communication is going to be between the school and the party, and advisors really have to rely on their clients to forward that information to them and to communicate what is going on with them. Once the report is out, each side will get at least 10 days to submit a response to the report. And in their responses, parties can make comments about any details that may be incorrect or missing from the report. After party responses are received, the school will consider the comments and then issue a second round of reports. So this process usually takes a very significant amount of time, and sometimes it requires that additional investigation be conducted to gather more information. The second report that is issued will summarize only the evidence that the school determines is relevant to the case. And at this point, the school may remove things from the report that it knows that the final decision maker will not be able to rely on in making a determination. Again, both parties will get at least 10 days to comment on the second round of reports. So what this usually means is that there will be almost a month in between the release of the first investigative report and then the finalization of the second investigative report. Schools are not permitted to hold the final hearing less than 10 days after the second report is released. Both sides must be provided sufficient time to prepare for the hearing. And usually the full process of the reports takes about 2 months. So I just want to talk briefly about FERPA. So FERPA is a federal law that protects students' privacy, and it applies both to K through 12 schools as well as to higher education. And it states that schools cannot disclose educational records without student or parent consent. And this can cause issues for you where a school may say that they cannot share certain information with you due to FERPA. However, Title IX trumps FERPA, and you should push back against this if any schools are restricting your ability to have equal access to evidence that is related to the case. Once the investigation is over and your client and all the witnesses have been interviewed, the rounds of reports and all comments are finished, then the adjudication phase begins. So under the 2020 regulations, colleges and universities are required to conduct a live hearing at which there is cross-examination. Prior to the 2020 regs, a live hearing was not required. The parties could just submit questions, and a neutral third party would then ask the opposing party those questions. But now schools must conduct live hearings during which both parties can see and hear each other in real time. This doesn't mean that the parties have to attend hearings in person. They can actually be conducted virtually, and most of them are virtual hearings. Both parties have the right to cross-examine the opposing party and to cross-examine any witnesses. Cross-examination is conducted by the advisor. So this is the one instance where the advisor is entitled to speak and to participate. Up until this point, schools are permitted to put a lot of restrictions on what advisors are allowed to do. So some schools will say that advisors are not allowed to say even a single word at any meeting, at any interview, or even during the hearing up until this point. And if either student does not have an advisor by the time they reach the hearing stage, one will be provided to them free of charge. Though I have not been involved in a case where I've seen this happen, so I'm not entirely certain what that would look like or how familiar that advisor would be with the facts of the case. Maryland law states that not only are schools allowed to provide a virtual option, but they are actually required to provide a virtual option to the parties so that they don't have to be in the physical presence of one another. And either party can request a virtual hearing. The fact finder, which is the person running the hearing and making the final decision, cannot be the same person who conducted the investigation, and they cannot be the Title IX coordinator. So in the past, investigators could and often did make recommended findings, and the Title IX coordinator would make the final decision. But under the 2020 regulations, an independent decision maker must be brought in. All of the decision maker's information must come from what's in the reports and what happens at the hearing. Unfortunately, what this does mean is that a lot of reliable credibility determinations that might have been made by the investigator, who has talked to everyone in the case multiple times, those determinations are lost because the investigator is no longer one of the people making the decisions. The hearing examiner, as well as the investigator or anyone else involved with the process, can be removed for bias. So that means that schools have to tell you who the hearing examiner is going to be and then give you the opportunity to challenge them for bias. What bias usually means is some kind of pre-existing relationship between the decision maker and one of the parties or witnesses. Sometimes people will argue that an investigator is biased because they used to work as a prosecutor or a defense attorney, or maybe because they used to work with an organization that works with survivors. But usually those kinds of arguments don't work unless a school is extremely worried about a lawsuit. So then the actual process of cross-examination is very different from what trial attorneys are used to. So instead of just being allowed to ask questions that are governed by the rules of evidence, advisors have to follow a process where they ask a question and then they pause to allow the decision maker to decide whether the question is relevant or not. The decision maker will then tell the witness whether or not they can answer the question. And under Title IX, the only evidentiary standard is relevance. So the only reason a piece of evidence will be excluded is because it's not relevant. There are no other evidentiary rules. So for example, there is no rule against hearsay that's admissible. Any other rules that are going to be imposed are going to be up to the school. And most schools will allow the students themselves to give some kind of an opening statement and a closing statement. Advisors do not give opening and closing statements, but rather counsel your clients on how to do that. So the clients should really be drafting those statements. It should be in their voice, and then advisors review and provide feedback. Some schools will allow advisors to interrupt and to make objections, while other schools will not. Some schools will allow advisors to conduct direct examinations of their own clients, while others will not, and the hearing officer will actually conduct those examinations. Some schools will also maybe allow for some form of redirect at the end of the hearing. The process is just really going to look very different at every school. And usually schools will hold a pre-hearing conference. And so these are the kinds of questions that you will need to ask. You should ask, all the questions that you need to find out what the hearing is going to look like, what you're going to be allowed to do as an advisor, what you're going to be allowed to say, whether you're allowed to object, how to point to places in the transcript or to the report, how to show evidence, all of those considerations. Okay, so as I said, Title IX does not define relevance, and that's really up to the schools to decide. However, there is an exception when it comes to sexual history. So under Title IX, the sexual history of a complainant is by definition not relevant. Any questions or evidence about a complainant's sexual history are not relevant unless it proves that someone other than the respondent committed the conduct, or if it concerns specific incidents between the parties and is offered to prove consent. So these are two very narrow exceptions. It's important to recognize that Title IX only prohibits evidence of a complainant's sexual history, not evidence of respondents. Prior to the release of Title IX, under Maryland law, schools could not consider the sexual history of either student, either the complainant or the respondent, except for a few exceptions. So to prove the source of the injury, to prove prior sexual misconduct, to support a claim that a student has an ulterior motive, or to impeach a student's credibility after that student put their own sexual history at issue. But under the current regulations, because they clash, the exceptions under Maryland law only apply to respondents. So respondents do still have some protections, but they don't have much. So there's a conflict between federal law and Maryland law, and of course the federal law trumps the Maryland law. Our attorneys at SALI have, we've seen a situation where a complainant put their own sexual history at issue, and then it turned out that what they said wasn't true, and the respondent was not permitted to present evidence that the complainant was lying to impeach their credibility. So even though this is something that would be permitted in a normal court case, it's not one of the permitted exceptions under Title IX. So Title IX hearings are just very different from usual court hearings. So it is written into the 2020 Title IX regulations that if a party or a witness does not submit to cross-examination at the live hearing, then the decision maker cannot consider any statement that party has ever made and cannot draw an adverse inference from the party or the witness's refusal to testify. And this rule has had a huge impact on hearings after it was first released. So for example, if a respondent confessed to committing the alleged conduct, but then refused to submit to cross-examination at the hearing, their confession could not be used. Their text couldn't be used, their interviews couldn't be used. Police records couldn't be used unless the police officer went to the hearing and submitted to cross-examination. And it was the same for safe examination results. So this caused a lot of evidentiary issues, especially because there's no subpoena power to make people come into the hearings and to testify. So in the case Victim Rights Law Center et al. Versus DeVos et al., it's a Massachusetts district court case. The judge found that the cross-examination requirement was a violation of the Administrative Procedures Act. And because it's been overturned, schools are no longer required to disregard statements made by parties who have not submitted to cross-examination. The Department of Education issued a letter that said they will no longer enforce that portion of the policy, so you cannot file a complaint about it or sue over it. However, there is nothing that says that schools cannot still have this cross-examination rule in their policies, and most still do. And you have to remember that Cleary requires that schools follow their own policies. So even though you may want to argue that it's a bad rule, that shouldn't apply, schools will need to follow it if it's in their policy. So it's something you definitely want to look at school policies to see if it's in there. The standard of proof. So under federal law, Cleary requires schools to state what standard of proof governs sexual misconduct hearings. Title IX states that schools are permitted to choose between clear and convincing or the preponderance of the evidence standard. Whichever standard a school does choose, they must use the same standard for all Title IX complaints, including those against or between faculty members. The standard for allegations between students must be the same as the standard used for claims involving faculty members. However, federal law essentially permits schools to single out sexual harassment complaints and to treat them differently from every other type of misconduct complaint. So sexual harassment cases under federal law can be subject to heightened scrutiny. However, Maryland law provides some protection against this and states that schools have to apply the same standard to sexual harassment cases as to all other similar types of misconduct cases that involve discrimination or harm to another person. So in practice, it appears that Maryland colleges and universities all use the preponderance of the evidence standard. We have not seen any higher education institutions in Maryland that use clear and convincing, because then they'd have to use that standard for all of their misconduct cases. Findings. So oftentimes the decision maker in these proceedings is an outside professional who is hired by the school. They tend to be former prosecutors, and they may not recognize that the normal rules of evidence do not apply to Title IX proceedings. So as an advocate, you'll want to be hyper vigilant that you are being allowed to get in questions that you should be getting in. Once the hearing is over, Title IX requires that the decision maker issue written findings. These findings tend to be very long because they must include the allegations, a description of all of the steps that were taken from the complaint through the final determination, what evidence was considered, the finding of facts that support the determination, the conclusion regarding the application of the code of conduct to the facts, and the rationale for each finding and any sanctions or remedies imposed. And because the process of drafting the findings takes a while, you will most likely not get any kind of decision at the hearing. You'll have to wait until the fact finder is able to write and issue the written findings. The rationale for findings is not only required by Title IX, but also by Cleary. And decision makers should not simply be issuing findings that just state, we find the respondent responsible because it was shown by a preponderance of the evidence that they committed sexual harassment. That would not be nearly enough. The decision maker has to explain how they reached their decision and what their reasons are. And the parties have the right to know what the remedies and sanctions are that are imposed, and they have the right to know what the appeal process will look like. Under both Title IX and Maryland law, both parties have the right to appeal. Parties have not only the right to appeal the final determination of responsible or not responsible, but under Maryland law, they also have the right to appeal the severity of the sanction. For example, if someone is found responsible and the sanction is to write an essay, the complainant can appeal and argue that the sanction is not severe enough. Or if the respondent is found responsible and is expelled, the respondent may appeal and argue first that they shouldn't be found responsible, and then alternatively that if they are still found responsible, that the sanction is too severe. Both sides should be provided equal rights to appeal. So under both Maryland and federal law, whatever bases a school offers for appeal have to apply equally to both sides. Under federal law, schools have to allow certain appeals. So they have to allow for appeals based on procedural irregularity, new evidence that was not previously available, or a conflict of interest or bias by someone at the school who was involved in the process. Most people will appeal as a matter of course. Often people may try to argue things like erroneous outcome or insufficient evidence, but those are not usually grounds for appeal. The most common ground for appeal that you're going to see is the procedural irregularity. Following the final decision, parties have 10 days to file an appeal. And then both sides will have 10 days to respond to the opposing party. Parties are not required to appeal, but if one party does appeal, then the other side should not only respond to that appeal, but they should file their own appeal as well. What this does is it helps to prevent moving the goalpost in one direction over the other, because two competing appeals just help to keep that goalpost in the middle. Any sanctions that are imposed by the school do not go into effect until either any appeal is decided or until that appeals period of 10 days expires. So if 10 days goes by and no one has filed an appeal, then the sanction goes into effect. If someone does file an appeal, this sanction is stayed until the school can figure out the appeal. Okay, and our last topic is retaliation. So all three of the laws that we've talked about today, Title IX, Cleary, and the Maryland Education article, prohibit retaliation. Schools are not allowed to retaliate against anyone for filing a complaint or for participating in the investigation process. Schools are also required to have a response if someone else at the school appears to be engaging in retaliation against either party. So for example, if a complainant's friends all start to harass the respondent, maybe following them around, calling them names, that could constitute retaliation, and the school is obligated to look into that conduct. However, Title IX does specify that it is not retaliation to charge a party with making a false report, provided that the allegation is not based solely on the outcome of the case. So essentially, as long as the person making the charge has some specific reason for why the report was false, and not just because the respondent was found not responsible, then the charge is not going to be considered retaliation under Title IX. Now, I would advise schools not to do this, to file such a claim unless they have a very strong basis for doing so, because it would have a chilling effect on plaintiffs who want to engage with the process. The best practice is to advise your client about the fact that they could get into trouble for retaliation. So if your client's friends are planning to make the other side miserable to try to get back at them somehow, you may want to tell your client to tell them not to do that, because the friends could be seen as acting as agents of your client. When the case is over, both sides should again advise their clients not to engage in retaliation. And if at any point there is retaliation, it will probably come up during the hearing. Someone will probably try to use it against your client, and it's just a bad look. It's not a good look for either party. So if a party has any control over it, they should definitely try to prevent it from happening. Okay, and that is the full presentation. If anyone has any questions, please feel free to ask those. I think we have, yeah, we're doing great on time. Oops, sorry, I just lost the presentation going to check for the questions. But if you don't have any questions now, please feel free to send me an email. I have it posted here. I'd be happy to get back to you. I'm also always available for technical assistance, mostly for people who work with complainants. And if you want to refer someone to Sally, we work with survivors across Maryland with a range of legal issues. So we don't just work on schools issues, but we work with a range of legal issues related to sexual assault. So we do peace and protective orders. We work on family law issues, crime victims' rights issues, employment discrimination, and a lot more.
Great. Thank you so much, Stephanie. I also would like to make an announcement that everyone will receive a copy of the PowerPoint slides that were used today, and you'll receive a copy of the recordings. So if everyone could please also direct your attention to the chat. I posted the evaluation link for this training, and we greatly appreciate all feedback. We're now going to go on to the lunch break, and we will return at 2:10 p.m. for the panel on the anatomy of a Title IX case. Thank you.